Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. It is 3 June 2026 years after Jesus, and we're back in the backyard again. Oh, yeah. Give you a little bit of the sound of the waterfall behind me. It's a little bit later in the evening, 7:30. At my common sense epistemology mentor, Dr. Doug Geivett's backyard. We've been house sitting for them since 2003. Like I've said before on the podcast, we're back in Benson, the Benson case, picking up on page 22 where we left off. And I'm going to show you how to get there. We're going to go ahead and let me show you, just like last time, how to do it. I'm going to share my screen, and feel free to call me Sharon. Hold on a sec. Hold up. Make sure I have the right thing up here. Case Benson, that's not the right one. Hold on. Hold up. Okay, I got it. Thank you for your patience. I'm going to do noise removal on, and I'm going to share my screen. Now, this is how you get to this. You go to District of Columbia courts, open to all, trusted by all, justice for all, in a district that voted Republican about 4%. So I'll leave that to you, that little slogan to you. You go to Court of Appeal. Well, you go to Home. Okay, first of all, there's Home. And you're going to encounter this. You're going to go to Menu, go to Court of Appeals, then scrolly-woolly to Opinions and Memorandum of Judgments. Should say memoranda, I would think, but maybe I'm wrong about that. Then you're going to search Benson, because that's the guy's name. And it's right there on the top. You see March 5th, 2026. You clicky little wiki on that, and it takes you to a PDF. We're scrolling down because we left off at page 22, and we're going to continue. But this guy was wrongly convicted. We stopped at any components integral to a firearms operation, like magazines, fit comfortably within the Second Amendment's protection of arms. Number 2, magazines holding more than 10 rounds are in common and ubiquitous use. The next question is whether 11 plus magazines are in common use for lawful purposes. While the parties agree that this is a critical question, they disagree about its precise import. A, the relevance of the common use inquiry. So that's where we're headed. In the district's view, whether 11 plus magazines are in common use informs whether they are arms at all. That is, the district posits that the common use inquiry informs the threshold question of whether the instrument at issue is a bearable arm and receives any Second Amendment protection. Benson and his amicus counter that whether an arm is in common use is irrelevant to the threshold textual inquiry of whether the capacity ban regulates arms-bearing conduct, quoting Rahimi at 602 U.S. at 691. We're on the top of page 23, which reduces to whether the instrument regulated is one that a person might useth in wrath to cast at or strike another. That's a quote from Heller, 554 U.S. at 581. Or whether it generally facilitates armed defense, self-defense. That's Bruin, 597 U.S. at 28. The inquiry we conducted above in Part 2B1. Okay, so they argue instead that the common use inquiry comes into play only in the next step of inquiry, where under Bruin's test, we consider whether there are sufficient historical analogs for banning arms in such common use. Okay, let's take a look at the pool for a sec, and I'm going to turn the pool sound on. You're going to be able to see the pool light here in a moment when the sun goes all the way down. It's sunset right now in SoCo. And like I said, this is not my home. This is someone we house sit for. He was my common sense epistemology professor at Biola University in the philosophy department for graduate school for my master's. He studied under Dallas Willard at USC to get his PhD in philosophy. If you don't have a common sense epistemology mentor, go out and get one. You can rent them by the day. I think for as little as $5.99.99. I might be wrong, but I have a coupon. If you want a coupon, I can send you a coupon. The coupon is from 1986, though, so it might be a little bit. I don't know if the barcode, you can still scan it. We used to have to scan that with a Kodak. You take a picture of it with a camera, then you'd have to go to Walgreens and get it developed. It only took an hour. But then once you got it developed, you would put your finger on the picture, and then the coupon would be mailed to you at some point. LOL. Let's continue. Let's go ahead and share my screen. Feel free to call me Sharon. Here we go. Now, like the parties, courts are divided on the import of the common use inquiry. Let's go ahead and just do noise removal. Okay. There's no consensus on whether the common use issue is a threshold textual inquiry, as the district asserts, or a historical inquiry pertaining to the permissibility of outright bans, as Benson and his amicus assert. Okay. We're going to skip these little side quotes. Page 24. This apparent tension in the Supreme Court's directives is best resolved by recognizing that there are distinct common use inquiries relevant at each step of the analysis. At the threshold inquiry, the Supreme Court has said that the sorts of weapons protected by the Second Amendment are those in common use, and that the Second Amendment protects the possession and use of weapons that are in common use. We take that to mean that an instrument must be designated or at least somewhat commonly used as a weapon to qualify as an arm covered by the Second Amendment. So, got the sheriff flying over us. Hold on. Keeping us safe. Thank you, Sheriff. All right. Thank you. Go get him. All right. Now, I don't know why I had you listen to that. I don't know why. I'm sorry I tortured you there. Anyway, okay, so while you could bludgeon someone with a taxidermied marmot, or beat them with a non-stick frying pan, a ban on stuffed rodents and regulations on Teflon cookware do not implicate the Second Amendment as a threshold matter because those instruments are not designed or typically used as weapons. This threshold inquiry is not an exacting one. If the instrument is the type of thing that generally facilitates self-defense, which, as we have explained, magazines of all sizes are, then it is in common enough use as an arm to receive some Second Amendment protection. At the next step of the analysis, when an instrument is in such common use that it is no longer unusual and ranks among the most popular arms possessed by law-abiding citizens, let's call that ubiquitous use to disambiguate the distinct meanings of common use. then by that virtue alone, it cannot be banned outright because there's no historical precedent for a ban on ubiquitous arms. Page 25 at the top. Heller made clear that any historical tradition of firearms bans in this country extends only to dangerous and unusual weapons, like short-barreled shotguns and fully automatic machine guns. Okay. All you NFA people are squirming right now. I know, I know, I know. One step at a time, okay? One step at a time. Let's get the magazines first, all right? Come on. Let's not snipe at each other here. All right. Well, that's me. All right, we got some in parentheses comments. Okay. Um the only historical tradition supporting complete prohibitions extends exclusively to bans on dangerous and unusual weapons. Heller and its okay, sorry. So, if 11 plus magazines are arms in common and ubiquitous use, the Second Amendment inquiry is over. Not only does the Second Amendment apply, sorry, I'm reading footnote 8 real quick. Okay. Not only does the Second Amendment apply as a threshold matter, page 26 at the top, but the district's outright ban on 11 plus magazines violates the Second Amendment. Dang, dude. Dang. Oh, let's celebrate that with a little song. Okay, original sound for musicians is on. This is the day. This is the day that the Lord has made, that the Lord has made. Come on. I will rejoice. I will rejoice and be glad in it, and be glad in it. For this is the day that the Lord has made. We will rejoice and be glad in it. This is the day. This is the day that the Lord has made. Oh my gosh. Doug's neighbors are looking at me right now. They're like, what is going on over there? What's that guy doing? Wasn't that a great quote? What do I got? What's the stick? It's a Toasty Jones, Skinny Maduro. I've got a few left from last summer. 250 buck chuck, and then just the cheapest Woodford Reserve with ice, and the ice is melted. So, all right, enough of that. Let's continue. Do you like that little chaplain's corner? All right, back. Now, Heller already made clear that the only historical tradition of banning arms extended only to those arms that are dangerous and unusual. Those of you who have taken sentential logic, propositional logic, will appreciate this is a conjunction. For a conjunction in a truth table to be true, both conjuncts have to be true. Both dangerous and unusual. Of course, any weapon is designed to be dangerous. That's the whole point of a weapon. That's the whole idea of a weapon, right? For self-defense. If you have a weapon for lawful purposes, like self-defense, for example, what good is it if it's not dangerous to the criminal, the immoral criminal, trying to harm innocent third parties, trying to severely injure you or another person, or cause imminent death, right? So what good would that be if it's not dangerous? So the really key issue is unusual, right? That's the second conjunct in the conjunction. So, and because arms in ubiquitous use are by definition not unusual, they cannot be banned outright. So there you go on the truth table, you got dangerous and unusual. Well, what if it's just dangerous? But the fact that the claim that it's unusual is false in the truth table, well, that would be enough to make the whole conjunct false. D and U, dangerous, they're dangerous and they're unusual. The dangerous part is true, but the unusual part is false because they're ubiquitous. And so that's what he's saying here. A little sentential logic for you, a little propositional logic I'm throwing in there because I taught basic logic at the college level for 15 years, and it's a it's a how you say an occupational hazard for me. Recall that Heller itself did not begin its analysis with the fact that handguns are the most common, that handguns are the most popular weapon chosen by Americans for self-defense. It ended there. That alone was sufficient to hold that a complete ban on them was invalid. Banning from the home the most preferred firearm in the nation to keep and use for protection of one's home and family would fail constitutional muster in all circumstances. Wow. B. Magazines holding more than 10 rounds are in common and ubiquitous use. That brings us to the critical question of whether 11 plus magazines are in common and ubiquitous use. They are. These magazines facilitate armed self-defense, and law-abiding citizens possess hundreds of millions of them in this country. You don't say. Okay, page 27. Skipping some of these in parentheses quotations. Supporting quotations in a bunch of parentheses. Okay, so that should be the end of this inquiry. There may well be some capacity above which magazines are not in common use, but that capacity surely is not 10. Don't call me Shirley. I'm looking at footnote 9. You can look at it with me if you want. Okay, I'm going to skip footnote 9. Page 28. The district raises several counter arguments and highlights that each of the 5 federal circuit courts of appeals have to have confronted this issue in the years after Bruin has upheld 11 plus magazine bans like the districts. The district and those courts raise 4 core arguments for why 11 plus magazines are not in common use in the relevant sense and thus may be banned. 1, that an arm does not need to be both dangerous and unusual to fall outside the category of arms in common use that cannot be banned. Bans instead might be appropriate on any arm that is unusually dangerous. Number 2, the ownership statistics we have just relied upon cannot be determinative of whether an arm is in common use. Number 3, Heller could not logically have prohibited bans on arms in common use because that would be circular. And 4, 11 plus magazines are not in common use because people rarely fire more than 2 or 3 rounds in self-defense. We consider those arguments one by one. Let me take a look at these footnotes really quick. I mean, I've already read this, but I'm just refreshing my memory to see if I have any. Looking at my printout here. Okay. Hmm. Maybe I will read something from footnote 9 really quick. Let me go back up to page 27 at the bottom. Um, to self-critique, I'm reading part of this footnote. Okay. To self-critique, we have also cited 2-1 study above from the National Shooting Sports Fund, a firearms industry trade association, which is nobody's idea of a fair and neutral source on this topic. But the problem for the district and the dissent is that there is no contrary authority, not even from the horribly biased source, that will say 11 plus magazines are less than ubiquitous because it is a plain counterfactual. To conclude that there are anything other than excuse me, to conclude that they are anything other than common and ubiquitous, you would have to ignore every study out there. We're on page 28 at the bottom, still in footnote 9. You would also likely have to avoid consorting with the third of Americans who personally own firearms, or the nearly half of Americans who live in a household with one. Ask just about any one of them, and they can tell you that 12, 15, and 17 round magazines are the norm rather than any kind of outlier. All right. Now, let's get to those arguments, okay? It's going to demolish the arguments now. Pretty fun, huh? First, well, let me just let you look at the pool for a bit. Just have just just have a nice time looking at the pool here. And think about, this is the day that the Lord has made. Let us rejoice and be glad in it. A little chaplain's corner for you. Mm. I was reading Psalm 149 yesterday for my Bible study. Have you ever read Psalm 149? I would seriously recommend that you read Psalm 149. I'm not going to tell you why. Just go ahead and read it. You see the pool light coming on? Yeah, it looks really pretty, huh? That teal color. This time of day is so pretty. And look at, do you see that flower there? It's really cool flowers, man. Let me show you. These flowers up here are just pink and they're bright and full, and the pool looks really great. It's cold though, man. It's cold. Nice little lawn area. We let two monarch butterflies out over there. They were in a little cage, and they were, well, they were in the cocoon, and then the cocoon turned black all of a sudden, like within a day. And the next thing you know, there's a freaking butterfly out there. It was pretty cool. Anyway, um, let's keep let's keep going here. I know that you don't care about butterflies. First, the district argues that unusual does not mean what you think it means. Oh, really? Okay. Is that right? You know, I didn't have the sound of the waterfall on when I was just showing you the waterfall. Sorry, I'm gonna. It's so much better when you have the sound of the waterfall, right? That's where we let the butterflies out right over there. This past Thanksgiving, there was a great horned owl right above there hooting while I was doing the podcast. We caught it on got on it was during reading the Bible with the founding fathers. Okay, there's a dog barking, so I'm going to definitely get rid of that one. Okay, let's demolish these arguments. What do you say? Now, um, the district argues that unusual does not mean what you think it means, i.e., that things in ubiquitous use like 11 plus magazines can still be dangerous and unusual in the relevant Second Amendment sense. The district maintains that dangerous and unusual is best understood as a Hendendades. I never know how to say that. Similar to cruel and unusual, or necessary and proper, where two words combine to form a single concept distinct from the meaning of the component parts. And in this case, that concept refers to any arms that are unusually dangerous, no matter how ubiquitous they are, or so the argument goes. That is a tortured argument. We cannot ignore what Heller and Bruin actually said, which is that, man, it is so loud here with that dog barking. I hope that you can't hear that. And I got a plane flying over me. Sorry. I hope you can't hear that. I got noise removal on, so I'm hoping it's. That is a tortured argument. We cannot ignore what Heller and Bruin actually said, which is that an arm cannot be banned unless it is both dangerous and unusual. The Supreme Court tends not to speak in code and usually means what it says, so that a weapon is not dangerous and unusual if it is in common use today. If the Supreme Court wanted to say unusually dangerous, it was quite capable of stringing the two words together in just that way, but it went with dangerous and unusual weapons instead. And to make itself especially clear, it juxtaposed dangerous and unusual weapons with weapons in common use, making it clear that it meant unusual in its ordinary sense, to wit, uncommon. Okay. Um, Let me look at my notes here. So he's citing Cayetano. That was a TRP episode we did. By the way, Hendon deities, that little thing that he was talking about, that's a hermeneutics issue. You should be aware of that. Um, okay, let me see here. Footnote 11, there's part of it that is relevant here. You might think the whole thing is relevant, but I have notes on um, uh, uh, our takeaway. It's right in the middle of the footnote on the bottom of page 30. Our takeaway is that after reviewing the body of historical authorities, Justice Scalia, Heller's author, and the rest of the majority, rightly or wrongly, concluded that any historical tradition of banning weapons extended only to dangerous and unusual arms, that this conjunctive test, remember I just said that this is a conjunctive test, right? It's conjunction. So the truth table would be a conjunction, and it would fit that model there. So this conjunctive test better captured the history of arms bans, and they rather deliberately endorsed that view and not the disjunctive version. See, that's a totally different truth table. A disjunction truth table is the whole disjunct is true. Dangerous or unusual. In complete sentences, they are arms dangerous. They are arms that are unusual. So that only one of those disjuncts has to be true for the whole disjunction to be true. But it's not a disjunction, it's a conjunction. It's a conjunction in symbolic logic. Okay. Um, so they rather deliberately endorse that view, the conjunction, and not the disjunction of it that sometimes appears in the same historical literature and seemingly would have led to a different result in Heller itself. Heller notably did refer to dangerous or unusual weapons elsewhere in the opinion, but only in describing one of the government's arguments that it would go on to reject. So this is basic logic, guys. Basic logic. What a concept. Page 31. Did we do this? Page 31. So still, even if we assume that Justice Scalia uncharacteristically and without warning used a Hendon deities, sorry, I don't know how to say that, in a vital portion of his watershed Heller opinion to mean something other than what he said, dangerous and unusual cannot possibly mean what the district asserts. If Heller meant to say that bans on unusually dangerous weapons were in bounds, then there's no telling why the court did not uphold the district's handgun ban. Very good. Very good. Handguns are unusually dangerous as compared to most other weapons like knives, clubs, swords, and bows. And given how easily they are to conceal, even rifles or shotguns, at least if you take assault rifles like the AR-15 out of the question. Okay, all right. Then he's good, good, good. He's quoting Kavanaugh dissenting on cert in Snope versus Brown, 2025. Oh, that's a good AR-15 quote. Kavanaugh, he's already said this, so he's not being unfair. He said it in 670, the third volume of the Federal Reporter, when he was on the DC circuit in 2011 in dissent. He said these are semi-automatic commonly owned uh, semi-automatic rifles. He doesn't use the term assault rifle. Um, I'm going to skip footnote 12. One of the district's core arguments in Heller was that even if the Second Amendment protects an individual right to bear arms, its handgun ban was nonetheless justified by how unusually dangerous handguns are. The Supreme Court did not cast any doubt on the premise of that argument. Handguns are, of course, extraordinarily dangerous. It simply deemed that point irrelevant because there's no historical tradition of banning arms that are overwhelmingly possessed for lawful purposes. Second, some circuit courts have held that 11 plus magazines are not in common use despite their ubiquity, reasoning that an ownership statistics approach to assessing what arms are in common use is too simplistic. He's referring to Duncan there. We covered Duncan dissents on the podcast last year. But that's like saying a tape measure is too simple a tool for measuring the width of a table, or that a thermometer is too crude for gauging the temperature outside. This guy's a good writer. When assessing whether an arm is in common use and typically possessed by law abiding citizens for lawful purposes, um, ownership statistics might not tell the whole story. They do not tell you if the arms are held for lawful purposes, but they tell most of it, and they are right on point. Just because a tool does not give you the measurement you had hoped for does not mean it is broken or ill suited to the task. Let's take a look at I would love for you to hear more of this waterfall, but I do have a dog over here who is obviously for gun control. This dog is a pro gun control dog. Lovely evening in SoCal. I think I'm going to go get another jacket though because I'm a little bit cold. I'm going to keep it recording. I'm going to keep it recording. I'll be right back with another jacket, okay? I'll be right back. Sorry about that. Wait, but I thought that you might want to look at the waterfall as you read this material. And in any case, I feel better. I got a scarf on now and a navy watch cap, wool, 100% wool. All right. Now, so the Ninth Circuit in Duncan. Oh, there's a case near and dear to our hearts here on TRP. Persisted in its attack on ownership statistics, positing that a reliance on them would mean that any time an undefined number of people owned an undefined number of arms, those arms could not be banned. That straw man of an argument is not at all what we mean. What we mean is what Heller said, that arms that are utterly ubiquitous in this country, like the hundreds of millions of 11 plus magazines, cannot be banned. Just as handguns cannot be banned because they are the most preferred type of firearm in the nation. The 11 plus magazines that tend to accompany them are the most preferred type of magazine and likewise cannot be banned. Duncan further critiqued the ownership statistic approach to discerning common use because under it, it seemed to the majority that machine guns could not be banned because there are an estimated 176,000 machine guns possessed by civilians. Okay, so that's an attempt by Duncan at a reductio ad absurdum, right? It would be absurd for machine guns to be banned. That's what he's saying, you know? Okay. Um, Looking at my notes here. Duncan further critiqued the ownership statistics. Sorry. Okay. But there is no difficulty in reconciling a machine gun ban with our holding today. 11 plus magazines are about 1,000 times more prevalent than machine guns are in the hands of civilians. Maybe there will be a difficult line drawing problem in determining where in between hundreds of thousands and hundreds of millions an arm becomes so commonplace that an outright ban on it becomes unconstitutional. I want to note here on the bottom of page 33 that Cayetano is relevant here. We did an episode on Cayetano within the last 6 months. I think it was December from Tennessee. And that was a stun gun case. And the question was whether stun guns are in common use. It's the same issue, whether they can be banned. That was a unanimous opinion by the Supreme Court. There were no dissents. Right after Scalia died, it was 8-0, March of 2016. So check out that. I'll link it maybe at the end here. So now on page 34 at the top, um, but it is not hard to tell which side of any conceivable line these 11 plus magazines fall on. Under no view are 11 plus magazines anything but in common and ubiquitous use. Besides, the Duncan majority is in no position to cast aspersions when it comes to line drawing problems. Well, that's really well said. It cannot explain why its reasoning would not equally permit a ban on 8, 5, or 2 round magazines, despite the dissenters' direct challenges to explain why its analysis would not permit such bans. Man, I'm sorry for botching that up. The Duncan majority is in no position to cast aspersions when it comes to line drawing problems. Excellent. It could not explain why its reasoning would not equally permit a ban on 8, 5, or 2-round magazines, despite the dissenters' direct challenges to explain why its analysis would not permit such bans. Referring to Van Dyke, his dissent. We covered that on the podcast last year. Third, the district argues that precluding prohibitions on firearms in common use is hopelessly circular because that would mean that once a firearm became sufficiently popular, there is no clawing it back. Put another way, the district posits that under the common use test, gun manufacturers and retailers would only need to race to make their products commonly possessed before any limitations could be enacted to forever prohibit such limitations under the Second Amendment. That argument has some logical force to it, but it is no more forceful now than when the district pressed it in Heller. And yet, the Supreme Court squarely rejected it and adopted the common use test anyway. Do I have any notes? No, I don't. Looks pretty good. It suggests, for instance, that Congress could ban the private ownership of a particularly dangerous weapon right after its invention before it grows into common use, yet not if its dangerousness becomes clear only after its use becomes widespread. Okay, so that's the claim. If the district wants to relitigate that fight, it needs to take it up with our brothers and sisters up the road at First Street. We're not in the business of grading the Supreme Court's homework, and whatever the wisdom of its Second Amendment holdings, they remain binding on us. All right. I'd like to know what you think about that. How'd that work? Work out okay? Is there something else that needs to be said? Page 35 at the top. In any event, the logical force of the district argument is limited in cases like this one, where the district is an outlier in putting any capacity limits on magazines. Very good. Very good. There are no magazine capacity limits federally, nor are there any in the vast majority of states, citing Bumate in Duncan. We covered his dissent on the podcast last year. So we won't quote that. You can just look at those episodes. The district's critique would be more forceful if this were a uniform federal ban on some class of arms that stood a chance of meaningfully diminishing the arm's ubiquity. The Supreme Court has not addressed anything like that since 1930s in Miller, and perhaps it will reassess its common use test if it crops up in a context of a federal ban. But there is nothing circular about saying that individual states cannot ban arms within their borders when they can be easily procured and brought into the state from elsewhere by people who pay no mind to the law. One could literally jog from the district to Virginia to procure a 30 or 50 round magazine, and one perfectly coherent view is that law-abiding citizens everywhere should have access to the same arms that are legal, widely owned, and generally available throughout the rest of the country. Page 36 at the top. Let's take a look at the pool. And let's listen to the pool. There's no dog. There's no dog now. We're getting through this, guys. We're getting through it. Having fun while we do it. All right. Isn't that fun? Not to bring up health food, but let us continue. Noise removal on. Fourth and finally, The district argues that 11 plus magazines are not in common use because it is extremely rare for an individual to fire more than 10 rounds in self-defense. Oh man, it's embarrassing that I just read that. The district again addresses the wrong question. Heller was not concerned with how often arms were actually fired in self-defense. It asked only whether they were typically possessed by law-abiding citizens for lawful purposes. Yeah. Skipping the supporting quotations in parentheses. Most firearms held in self-defense will never be fired in self-defense at all. That cannot justify a ban on ammunition simply because it is rare for law-abiding citizens to actually shoot some attacker, or because blanks might suffice to scare most attackers off without live ammunition. Page 37 at the top. Moreover, we have no doubt that law-abiding citizens do regularly fire more than 10 rounds for lawful purposes like target practice and marksmanship, and the Second Amendment's protections extend to those activities as well. Because 11 plus magazines are in common and ubiquitous use for lawful purposes, the district's outright ban on them violates the Second Amendment. We're on page 37, and we're stopping here at number 3. There is no historical tradition of banning arms in common and ubiquitous use. So we'll pick up there next time. Let's have a little time with the pool. Little sound there. Lord, thank you for this decision here in the District of Columbia Court of Appeals in the case of Tyree Benson. Lord, we know that he was wrongly convicted, and we thank you for justice in this case. We ask that it would be affirmed on appeal. Lord, we know that the tyrants are among us, and we're asking for your help in standing up against them so that innocent lives can be spared, so that we don't criminalize innocent conduct, which is one of the worst things that a government can do. All tyrannies do that. They criminalize innocent conduct. All tyrannies do that. Lord, we know that where the Spirit of the Lord is, there is liberty. And we ask, Lord, for you to help us love our neighbors as ourselves, asserting justice, loving mercy, walking humbly with you. In Jesus' name, amen. Thanks for joining me on the Republican Professor Podcast. I've been your host, Dr. Lucas J. Mather. I'm in the backyard of my common sense epistemology mentor, Dr. Doug Geivett, and we've been thinking through this wonderful decision styled as Tyree Benson versus United States, District of Columbia. We'll talk to you guys later. It is 3 June 2000, 26 years after Jesus. It's a Wednesday. It's 8:25 p.m. I'm going to get in the spa. Take care, guys. See you. God bless.